Thank you. My presentation today will be looking at some of the ways in which states are responding to the new threat presented by cyber attacks and cyber warfare. As such, I'll be looking at the following questions. Do governments take into account the IHL framework for cyber operations in armed conflict, and how do they ensure that it is respected? Are there any strategies, directives and training on this issue, and how do governments consider that challenges posed by cyber warfare should be addressed? In dealing with the question of cyber-based attacks, there are a number of problems that arise for lawyers and lawmakers in regards to international law and computer network attacks. The first of these issues, which has been alluded to by speakers, is the absence of an internationally accepted definition of what constitutes a cyber attack, and whether such an attack can actually give rise to a right of self-defence under the UN Charter. It has been essentially left to states to define cyber warfare and cyber attack for themselves. Thus, so if you have a look to how the United States has defined cyber network attacks, they define cyber operations as the employment of cyber capabilities where the primary purpose is to achieve military objectives or effects in or through cyberspace. And thus a computer network attack are actions taken through the use of computer networks to disrupt, deny, degrade or destroy information resident in computers and computer networks or computers or networks themselves. A number of countries, the US included, have actually gone on the record as saying that they will consider a cyber attack as an act of war. So this clearly raises problems for international law. Perhaps one of the biggest ones again that has been alluded to by Richard is the question of correct attribution. This map shows some of the countries that have been subjected to coordinated cyber attacks. And you will see some of the hypothesized sources of these attacks. And I say hypothesized because none of these attacks have actually been proven or verified as to their origins. For instance, in regards to the infamous Stuxnet attack, which crippled technology at the heart of the Iranian nuclear enrichment program, it was only through rumour and supposition, as well as what was an overly revealing retirement speech for the outgoing head of the Israeli Defence Forces, that a potential source was revealed, and that was possibly Israel with the help of the United States. Third problem of the states lies in the amount of time it actually takes to ascertain the existence of an attack and repair any damage done. As you can see, the Stuxnet attack was actually released in March of 2010, but it was July before any computer security experts working for corporations in this instance actually found out what was going on, and it was September of that year that the source was finally kind of settled upon. So as you can see, it really does take a while to respond, which as any military theorist or strategist knows is contrary to the nature of military strategy. Finally, an additional problem for law and policy makers, as well as for armed forces personnel, is, as I said, the difficulty in determining the source of the cyber attack. As we have seen, cyber attacks can come from any number of sources. They can come from individuals who are seeking to create disruption for its own sake. They can be from so-called hacktivists, groups of hackers who are attempting to disrupt government and industry for political purposes, or they may genuinely come from the state's armed forces or be sponsored by a state as part or whole of an attack against another state. As you know, under IHL, there are different types of armed conflict and they have different applicable rules. There are certain actions that are permissible in non-international armed conflict that are impermissible in international armed conflict. And thus, when the source of an attack is difficult to locate and find the origin for, the appropriate legal response is thus difficult to formulate. Due to these difficulties in attribution, the general trend among states that has been alluded to here has been to treat all cyber attacks, regardless of origin, in a similar manner. The main objective has thus been one of prevention and defence mechanisms. So you're starting to see the evolution of the kind of national bodies that have been established to deal with cyber threats, that amalgamate both the threat and threat response under the umbrella concept of cyber security. So in Australia, we have the recently created Cyber Security Operations Centre. It was established last year as part of the Defence Signals Directorate, which is mainly a security-based organisation, and it includes personnel across a number of different areas, including the Australian Defence Force, the Defence Intelligence Organisation, the Defence Science and Technology Organisation, the Australian Security Intelligence Organisation, the Attorney General's Department, and the Australian Federal Police. And if you have a look at countries around the world, you'll see a very similar body with a very similar spectrum of participants has been established. With regards to the legal response to cyber war, if you have a look at the policy papers of governments of the United Kingdom, of the Netherlands, Germany and the United States, almost all of them will draw attention to the fact that they see that there are gaps in the law regarding cyber attacks. The initial attempt has been to address these gaps focusing on domestic laws, looking at things like telecommunications laws, domestic criminal laws, or critical infrastructure protection laws. At the UN level, this has been repeated. Resolutions have called upon member states to enforce and reinforce their domestic systems rather than calling any attention to developing some kind of international response. Another common response that is alluded to by our second speaker has been the establishment of national CERT, computer emergency response teams that are designed to mobilise quickly and respond to major national computer security incidents. Traditionally, these teams were run actually out of universities in conjunction with business and with industry, but what we've started to see over the last few years has been the government getting much more involved in coordinating and organising national CERT. So as you can see, the focus has been essentially one of defence, protection and detection. However, there is still uncertainty regarding the international law applicable to cyber attacks, and there is a general awareness of the need for new international laws and policy on cyber warfare. And as has been noted, the Russian government has become advocated the introduction of an international treaty on cyber warfare. And we are, if you have a look at the state of national policies of countries, we're starting to see states tentatively formulating rules on the conduct of cyber activity. And you can really see an awareness on the part of state defence forces that there is an awareness that there are rules that should be followed, they're just not entirely sure what they are. I've chosen a few examples of state policy to illustrate, focusing mainly on the United States simply because theirs is one of the more developed and they are the most open about their policies. Last year the US created their US Cyber Command called CyberCom, and it announced that it was developing policy regarding rules of engagement for cyber operations. And they said that the doctrine, once adopted, will help define conditions in which the military can go on the offensive against cyber threats and what specific actions it can take. In a recent public statement, US Cyber Commander Keith Alexander stated that even though current training focuses on how to secure the Department of Defence networks and how they're going to protect them, they're actually looking to broaden their training to include a more full spectrum operation against threats. Keith Alexander has stated that the US must determine what represents a reasonable and proportional response to cyber attacks. They're aware that the law of armed conflict is applicable, but they are unclear as to how the law of armed conflict applies to cyberspace, whether it includes authority to shut down computer networks, even if it's been taken over by a malicious cyber attacker intent on destruction. We also raised the concerns about there's a lack of awareness as to who would be responsible for answering a cyber attack, whether that would be the FBI, the National Security Agency, the military, or whether that responsibility would fall upon internet service providers. However, at the same time, if you have a look at the military manual, the military policy manual, for instance, the United States Air Force stated in their 2009 Air Force Operations Manual that the fundamental targeting issues arising are no different in cyber operations as compared to those applicable to kinetic targeting, and that those relevant principles must necessarily include proportionality, distinction, military necessity, and the prohibition on unnecessary suffering and superfluous injury. And if we have a look across most of Europe and have a look at their policy, we can really see very similar policies. In the UK, their cybersecurity strategy made particular note of the principles of necessity and proportionality in the conduct of cybersecurity operations, and they stated that our approach to national security is clearly grounded in a set of core values, including human rights, the rule of law, legitimate and accountable government, justice, freedom, tolerance and opportunity for all. And the cybersecurity poses particular challenges in meeting the test of necessity and proportionality, as the distributed and decentralised form of cyberspace means a wide range of tools must be deployed to tackle those who wish to use it against, use it to harm the UK's interests. And then if we have a look at the Netherlands National Cybersecurity Strategy, we see that they also point to the importance of proportionality, and they say an appropriate balance must remain between, on the one hand, our desire for public and national security, and on the other, the safeguarding of our fundamental rights. Measures must be proportional. In reviewing the available policy documents and the other literature, the general consensus seems to be that what is missing is not so much the law, but rather the policy. In all of the relevant documentation, there is keen awareness that the law relating to the conduct of hostilities as it stands now is both sound and instructive, but the policy is where there is the gap. The military lawyers and policymakers need to make it clear as to how the applicable law can be translated to apply to this new military domain. However, the dire warnings about the lack of relevant law regarding cyberspace seem to be in large part unfounded. States seem to be taking almost entirely defensive rather than offensive position with regards to cyber law. As such, the purported lack of law with regard to cyber law may actually be moot. Indeed, the United States has said that it's the very nature of the internet, with its anonymity and its difficulties in attribution, that is shaping state policies regarding the conduct of cyber war. At the July launch of the US Department of Defense Cyber Strategy, Deputy Secretary of Defense William Lynn emphasised the US position was always going to be one of prevention and defence rather than retaliation. Lynn specifically stated that there was more benefit to the United States in ensuring that any possible cyber attack was detected and reported at the source, and as in an attempt to deny any attackers the benefit of the attack, rather than focusing attention on a retaliatory response. His position was that it is much more important to make sure that the benefit of the attack is actually denied to the attackers, rather than to let the attack happen, have this kind of catastrophic effect throughout the society, and then retaliate likewise against that country. So we are really seeing perhaps a shift in military policy and thinking. So today we read this kind of a very basic summation of current state policy with regard to cyber attacks. Thank you.
Jadi itu tadi kita